Hello, in this video I'm going to explore some more claims in the Hugo Young book, starting with an accusation about Harold Macmillan in the Agonising for Britain chapter. No sooner had he led the cabinet to take the plunge than he did almost everything to pretend to the world outside that the water was tepid and its depths were shallow. Thus the political formula was established which has laid its hand on the British approach to Europe ever since this first effort was undertaken. It would sit aptly as an epitaph. It dictated the way every subsequent leader presented every move towards Europe. It speaks loud and clear from the record of Harold Wilson, of Margaret Thatcher, of John Major, and even to some extent of Edward Heath. It was, in essence, a lie. It said, on the one hand, that this move, whatever it was absolutely essential for the British national interest, but at the same time it asserted nothing whatever would change in the British way of life and government. So let's have a look at that, shall we?
It is a bracing cold shower we shall enter, my Lord Chairman.
Common market, bracing cold showers, Mr. Macmillan. Painful changes ahead. You can't really say that's tepid waters now, can you? But okay, that was just economic changes. What about the way of life? Well, the British made a speech at the opening of the negotiations. Shall we take a look at that? Edward Heath said, "There can be no doubt that the success or failure of these discussions will determine the future shape of Europe. This will affect profoundly the way of life, the political thought, and even the character of each one of our peoples." But that was Edward Heath. What about John Hay, the Parliamentary Secretary at the Transport Ministry, who said, "The decision to seek entry to the common market represented a very great change for the British people." Then there's the Commonwealth. That has to change. Common market will bring changes, but we must welcome them. And let's look at the final major speech of Harold Macmillan. The European Economic Community is one of the facts of the modern world. It is there, and its very existence must cause profound changes. This is just as true whether we go in or whether we stay out. Again, we're back to something which is objectively false. But Hugo gives an example, so let's look at that. In the fissile effect, he talks about how sovereignty is dealt with. The Yes campaign dealt with the matter differently. I traced no major document or speech that said in plain terms that national sovereignty would be lost, still less one that categorically promoted the European community for its single most striking characteristic, that it was an institution positively designed to curb the full independence of the nation-state. Seldom, if ever, did the leading speakers address specifically the implications of the European Court of Justice. There was plainly much wariness about exactly how much to say and in what context. The official Yes campaign document described the legal question, for example, as follows. English common law is not affected. For a few commercial and industrial purposes there is need for community law. But our criminal law, trial by jury, presumption of innocence remained unaltered. So do our civil rights. Scotland, after 250 years of much closer union with England, still keeps its own legal system. While not untrue, this could be said to somewhat understate the matter. It certainly conformed, as did the entire Yes campaign, to the old familiar rule, the golden thread of deceptive reassurance that runs through the history of Britain's relationship with the European Union up to the present day. Our entry was essential. Our membership is vital. Our assistance in the consolidation is imperative, but nothing you really care about will change. If you watched my first video on this, you'd know that the sovereignty was laid out by the UK government at the start of the referendum, saying the question of whether this change is acceptable has to be considered in the total context of the advantages and disadvantages of community membership. It's essentially a cost of membership, so it shouldn't come as a big surprise to not find it in the arguments for staying in. However, there was one notable speech in the most watched debate in the entire referendum. It was highlighted in the 1975 referendum book by David Butler and Ewa Kitzinger, and it is Edward Heath's speech to the Oxford Union. The problem is, Hugo should know this. He has this book. He is quoting from this book, and he says he has drawn from this book for other details in this chapter. Doesn't look good for Hugo Young, to be honest. Anyway, it's not that debate that would answer his question about what the Yes campaign said. It is this one from October 1962. In a speech at the Conservative conference, Edward Heath said, "Never at any time have we hidden the fact that these political issues loom foremost in these decisions. The same questions arise with sovereignty. It was, I think, a little naughty of Sir Derek Walker-Smith to raise again these questions about the powers of the Commission entering into firms and so on. We have debated this in the House of Commons. We all know that this can only be done through the British courts, that these powers of the Commission are very limited, and that the organisation of the European Economic Community is not, as Sir Mr. John Paul said, an authoritarian, totalitarian system." Edward Heath is referring to Regulation Number 17, and it was a gift to the Eurosceptic cause. Gestapo-type regulations if Britain joins common market. Joining the common market will involve the de facto suspension of habeas corpus by which the liberties of all British citizens are at present protected. Regulation 17 of Articles 85 and 86 gives power to the European Commission's secret police to examine the books of any person or business in this land, to make copies or extracts, to demand oral examinations on the spot, and to have access to all premises, land, and vehicles. This Gestapo-like regulation is noteworthy for the fact that it makes it obvious that the Commission combines the roles of executive, judge, and jury. No impartially granted search warrant has to be obtained by the Commission's secret police, and no impartially adjudicated hearing is provided before the levying of penalties. To whom will the hard-pressed British citizen be able to appeal? No one. It is not the European Supreme Court we should be worried about, as Mr. Gover suggests, but the European Economic Commission with its 9 faceless bureaucrats responsible to one. It goes on. In all these important respects, the sovereignty of Parliament, that is Britain's power to rule herself, would be fettered if not eventually destroyed. Nor would the rule of law remain unscathed, for English judges would be interpreting what would be in effect continental laws, drafted in an idiom entirely different from their own. That was from the Reverend E.L. Hebden Taylor, Vicar of Greengates. And what he says is kind of true. The Commission is both policing the treaty and they are the judge in this situation. There is no separation of power, and it is very controversial. But he also alludes to how the court might affect our law, and this comes to the next point. What is going to happen to the presumption of innocence? In this debate from 1962, one questioner asked whether the provisions in the Treaty of Rome for standardization of various services might not result in Britain having its priceless common law system replaced by the canon law of continental countries, with its adverse effect on the position of the accused in criminal cases. We are told in 1967, Article 164, which is the court, would necessitate the wholesale exchange of the legal system. At present, the basic of justice practiced in the courts is the common law of England, as opposed to the Byzantine Roman law on the continent. Under the latter, there is, for instance, no provisional safeguard of habeas corpus, which explains why in foreign countries an accused may languish for long periods in jail without the formal charging and institution of proceedings and searching interrogation by the police. Then, too, there is the basic difference in that under English law, a man is held innocent until proven guilty, and in case of doubt must be given the benefit, compared with the continental requirement for the accused to prove innocence. While criminal proceedings may not be effected immediately, constitutional and civil law would require repeal or amendment at once. And again, the Court of Justice of the Common Market exercises jurisprudence founded upon Byzantine Roman law, Articles 164 to 188, of the Treaty of Rome. Therefore, if we accept this treaty, the common law of England must be replaced, however slowly, by the continental law. Even our criminal class should be perturbed at the prospect of the loss of the safeguard of habeas corpus. So the argument is put forth that the European Court of Justice will slowly erode common law. These arguments continue into the 70s. Here is someone passing out a leaflet called The Queen and the Common Market. You can find it being referred to in Hansard. As Anthony Butt said, it suggests at the end that our common law and our jury system, indeed our whole legal system, will be put in peril if we enter the common market. Going on to say, there is, as I understand it, no power even for the court to impose a fine or to send anybody to prison. Yet we have had so much scurrilous comment about the possible impact of this court on our affairs. This is the sort of propaganda that has been doing the rounds. The loss of the presumption of innocence is also an argument that's still around in the 1970s. Here it is in the Daily Express. As Judge Kerry Evans warned as long ago as 1962, when Mr. Heath, then a cabinet minister in Harold Macmillan's government, first flirted with Europe, it is the pride of our common law that the prosecution must always prove its case to the satisfaction of the jury. But don't ask me what will happen when we get into the common market. As for common law, Eurosceptic papers had one argument, that there would be no common law. But the whole purpose of the community, as the government's white paper admits, is the creation of a Europe united, in which case separate systems of law would have to give way to a European law. FCO 301048 shows examples of the government trying to answer these questions, including the presumption of innocence and of course Regulation 17. Here the government are looking for statements from all the 6 members on how they stand in terms of the presumption of innocence, specifically France, who had not subscribed to Article 6.2 of the European Convention on Human Rights. They are certainly not very impressed with Regulation 17 either. Simply as a matter of form, and irrespective of the possible impartiality of the procedure adopted in practice, it may be said that a hearing before a person who is appointed by the prosecuting authority can scarcely be thoroughly impartial. They clearly weren't fans of Regulation 17. It was controversial for a reason. And now if we go back to the statement that Hugo originally highlighted, you can see that it addresses the very fears around the court. This leaflet came out in the final days of the referendum, which means we've been discussing this for 14 years. This leaflet has been written assuming that people understand the issues, unlike Hugo Young, whose analysis assumes that nobody has learned anything in 14 years, which is unlikely. Regulation 17 was still controversial at the time that Hugo was writing his book, but because it's no longer a Eurosceptic talking point in the 90s, he does not seem to know about it. He certainly doesn't mention it in the book. Again, Hugo doesn't seem to understand the sovereignty argument from the 60s and 70s. He is reading it entirely through the filter of the sovereignty argument of the 1990s. Otherwise, he'd have seen that sentence and known exactly what he was referring to. And Hugo's not the only one to do this. Days before the referendum vote, Full Fact brought out this article. It says, one Yes campaign claim, which with the benefit of hindsight we can say was not true, was that English common law would not be affected by staying in the European community. We now know that EU law has a significant effect on UK law. Which means they took the title, they removed the qualification, and then they took it out of context. And they do it by linking to an article about supremacy. And not only is it out of context, we don't need the benefit of hindsight. We knew about supremacy. That was also in the case that the government published at the very beginning of the referendum. Even Hugo acknowledges that the sovereignty comes out early, but he says, and we've seen it before, that in Macmillan's version of the case the sovereignty issue barely featured, that there was no prominence to the Kilmer letter, and that he was silently evasive. He then refers to a speech he made on the 2nd of August in the House of Commons, and that's what we need to look at. In the Cabinet Minutes of the 27th of July 1961, we learn that there is a sovereignty revolt on the cards. In response, the Cabinet decided to change the motion to add a special undertaking to consult Parliament about any agreement which affected the special interests of the United Kingdom, in particular agriculture and of the Commonwealth and EFTA, or involved British sovereignty. So it's worth mentioning that in his speech on the 2nd of August, Harold Macmillan is actually offering full transparency on sovereignty. And the sovereignty is out by then, because that's what Kilmer wanted, wasn't it? Hugo refers to these words twice in his book. But these objections ought to be brought out into the open now, because if we attempt to gloss over them at this stage, those who are opposed to the whole idea of joining the community will certainly seize on them with more damaging effect later on. Hugo Young then says this proved to be a prophetic statement, and then refers to the Goldsmith conspiracy. And although he denounces the Goldsmith conspiracy, he then treats this in kind of a weird way. He writes, "It is true that perceptions of what membership meant for sovereignty were more luridly understood in 1997 than 35 years earlier, but that was not, I think, primarily owing to the calculated neglect of the politicians of the day." He then goes on to say that Kilmer told the House of Lords, without excitement. His successor, Lord Dilhorne, also told the House of Lords, and the Bow Group produced a study. I don't think this is Hugo Young's fault. This is very Westminster-centric. If you weren't from Westminster, to paraphrase Douglas Adams, you might think the sovereignty was on display in the bottom of a locked filing cabinet, stuck in a disused lavatory with a sign on the door saying "Beware of the leopard." Hugo Young seems happy that he hasn't fallen for the Goldsmith conspiracy, but in reality, he kinda has. The Kilmer letter isn't prophetic. It was written on the 14th of December. The British government aren't joining on the 14th of December. Edward Heath is supposed to be looking at a solution that involves EFTA and some kind of trade link. In fact, he stated in that year that the Treaty of Rome could not be signed by Britain as it stood. And that's the important point. The 1961 application wasn't an application to join the treaty so much as a negotiation to see what we could get in terms of derogations. So when Lord Kilmer says we need to get them out at this stage, he's referring to the negotiation phase. When he talks about people seizing on them later on, he is talking about when the government brings back the final negotiated deal. When Lord Kilmer says now, he doesn't mean today. The Cabinet doesn't get a report until April, and he certainly wouldn't be suggesting that Heath delivered this information with assumptions. For Heath could deliver the sovereignty that day, before the report was written, and without the assumptions. The Goldstream conspiracy assumes that Lord Kilmer is the only person who can read a treaty, that he had some seeing stones that he put in his hat, and then he read out the sovereignty from the Treaty of Rome, when in fact lots of people in the UK could read treaties, as long as they were in English. Just one problem: the Treaty of Rome is not in English. Here is the translation that the Foreign Office made for the convenience of Parliament and the public. And here is Derek Walker-Smith asking if there will be a white paper on the constitutional implications, of which Harold Wilson replies, "Copies of the official English translation of the full Treaty of Rome, including the annexes, are in the Vote Office." The Prime Minister is asked again, is there going to be a white paper? And he replies, the sovereignty is clear in the treaty. How clear? Well, let's have a look at the Daily Express from September the 16th, 1962. But what is Mr. Macmillan demanding? The right to sign a treaty, irrevocable for all time, which provides that regulations made by the institutions in Brussels shall override anything the British Parliament may decide. Article 189 of the Common Market Treaty says, in plain terms, regulations shall have a general application, they shall be binding in every respect and directly applicable in each member state. I emphasise those words, directly applicable. There is no iota of the suggestion that the British House of Commons will have any say in the matter. At no time in the past year has the industrious Mr. Heath sought to amend this provision. So while the principle of supremacy did not come about until 1964, it really only gave effect to what is written into Article 189. And here is Edward Heath acknowledging direct effect and talking about the regulations being applied. He says, "This matter has been under review by Her Majesty's Government, and we shall place all the information about it before the House when the appropriate time comes in the negotiations." He also speaks about some of the issues to do with Regulation 17. But you didn't need to be in Parliament. Things like Article 189 are starting to get into the public debate. They're on radio shows. I don't know for sure, but I assume it made it onto television. This televised debate has Derek Walker-Smith. Sovereignty was one of his things. In 1967, there was a radio programme about sovereignty with Hugo Kittinger. In the Radio Times write-up, you will find the line, "In 1962, there was much discussion of the surrender of Britain's parliamentary sovereignty if we joined the EEC." That's certainly different from the impression that Hugo Young gives in his book. That's not to say everybody in 1962 knew about this, but not everybody in 1990 knew about this either. the difference being that in the 1960s and 70s the common market was new.
This programme is going to be about Britain and Europe. It's one of the great issues of the day, and rightly so, for much depends upon it.
There was a lot of content to explain what the common market was, in opposed to 1990, when you were more likely to hear about banana regulations. Hugo Young doesn't seem to understand that, and that shows in his handling of Macmillan's pamphlet. He says the plainer depictions of Lord Chancellor Kilmer were watered down for public consumption. What the pamphlet actually says is, it is sometimes alleged that we would lose all our national identity by joining the European community and become what Mr. Gaitskell contemptuously described the other day as a mere province of Europe. He goes on and says, accession to the Treaty of Rome would not involve a one-sided surrender of sovereignty on our part, but a pooling of sovereignty by all concerned, mainly in economic and social fields. This may not be what Hugo Young wants Macmillan to say, but we are now in a world where Gaitskell is giving a major speech saying we might become like Texas or New South Wales. Considering this major speech was reported on October the 9th, 1962, and the Macmillan pamphlet was published in the Daily Mirror on Thursday, October the 18th, 1962, it's important to remember the pamphlet was published as a response to the Gaitskell speech. This is a rebuttal rather than an information pamphlet, and he doesn't go into areas that Gaitskell didn't go into. And another thing that Hugo Young misses is not saying something is worse than saying something. If the government doesn't talk about sovereignty, somebody else will. Time and Tide published their own sovereignty article. It was prepared, they said, by distinguished lawyers. It said the status of the sovereign would be diminished, her appointment of ambassadors and consular staff would probably cease, the right to declare war or to end it would no longer be the Queen's, and the paramount head of state in Europe could declare a state of emergency in Britain and the Queen could not overrule him. The fact is, if this is going to be a United States of Europe, and we're going to become Texas or California or New South Wales, the people have other concerns about sovereignty that go way beyond what happens to Parliament. Hugo says, for one school of conservatives, the issue of Britain's survival as a sovereign nation was the inextinguishable heart of the matter. Why restrict it to some part of the Conservative Party and not the whole population? Because clearly there were concerns.
Joined with other nations in trying to build a world community in the future.
Yeah. What about the
No, I don't think we should. I think Britain would suddenly disappear if we joined the common market.
These were still part of the Eurosceptic argument in 1971. Here is Neil Martin saying that their real concern for sovereignty is that we will lose Parliament within 15 to 20 years. If Europe would speak with one voice and become an economic force to rival America and Russia, it could only do so as one country. Now, if it's going to be one country and it's going to have one parliament and it's only going to have one type of law, then the Eurosceptics are effectively arguing that the constitutional implications for parliament are only temporary. The actual constitutional sovereignty doesn't become an issue until 1972, when certain politicians decided they were surprised at what they've been discussing for 10 years. But that's not saying that supremacy is an issue for the British public before that. In 1971, the British public are worried about supremacy, but not the principle, the practice. The British decision to join the common market will soon be irrevocable, according to an article in the French newspaper Le Monde. But because of certain quaint beliefs, the British people are opposed to entry. Among the delusions found by Mille Michel is the conviction that the British way of living will disappear and that Britain will lose its identity through obedience to edicts from Brussels and thus to a non-democratic authority, which will rank Britain as nothing more than a European province. People are asking, are they going to tell us if our beer is going to taste different, or
are they going to say, well, you're not going to have your government, we will have the government in Brussels?
With the knowledge that the European Parliament will be a proper parliament, the British project their idea of the UK Parliament onto it. And with that comes the idea that they can pass a law which is supreme to our Parliament, which will actually shut our Parliament down. The constitutional part of supremacy isn't really made an issue of, but the fear of what might happen with supremacy, that is part of the argument. Or the term is used just like garnish. Mr. Benn said that if the Treaty of Rome was signed, Future parliaments would be tied by the superior European economic community law, and the power to tax people would be taken, for certain purposes, by authorities not answerable to an elected House of Commons. The change would be irreversible. You would see the irrevocable argument and the supremacy argument together a lot. And that's down to Article 240. This treaty is concluded for an unlimited period. The idea that if this is supreme, then Parliament will not be able to leave. Here is an example of an exchange from 1975.
Make a note of this in your children's diaries. You can get out of the coal steel pool on the 19th of April in the year 2001. But to get out of the common market, the rest of it will be much more difficult because the other two treaties are for an unlimited period. That means forever and ever, ladies and gentlemen.
You may have given some people the false impression in your early remarks that the decision to go into the market or to stay in the market would be irrevocable. You talked about two of the treaties having no time limit, and you mentioned the relationships between the courts and government and parliament. Could I obtain your acceptance of the following 2 points? First, that it is constitutionally impossible for Parliament to tie its own hands with regard to the future. If at any time in the future, Parliament thinks that it is in the interests of this country to wholly or partly change our treaties of obligation to the EEC, then Parliament will be free to do that. And secondly, that the courts of this country cannot overrule any decision that is made now or will be made in the future by the British Parliament.
On the first point, yes. The answer is yes. 3 Lords Chancellors have told us that the British Parliament cannot get rid of unload its right to change any law that has been made by a previous British Parliament. It is therefore entitled in law to change or withdraw or modify the European Communities Act. That I think there is no doubt about at all. Whether it will always stay so, I'm not sure. That's a very difficult point. If at some point the British courts decide that they have to line up with some judgment of the European Court in Luxembourg, which they may feel, that might cease to be true. It's speculative. I don't know on that whether the answer is yes or no.
Mr. Pickles, could you deal with his second point as to whether the British courts would in fact overrule an act of Parliament?
Oh, the British courts will overrule an act of Parliament if they're told to do so by the European Court in Brussels.
William Pickles accepts that Britain can leave, but he also suggests that the ECJ may make a decision later on which stops them from leaving. He also says that the British court would overrule an act of Parliament if the European Court told them to. And the problem with that is it's not correct, but it is consistent with something you might hear in the 1990s.
Now, are those supreme over British law, or is British law still supreme? Well, this is what the court itself, the European Court of Justice, has said. It said the essential characteristics of the community legal order which have been established, are in particular its primacy over the law of the member states. In other words, British law, as passed by Parliament, is no longer supreme.
And along with primacy of law, in 2016 you might have heard things like direct effect and supremacy. But in 1971, you might have heard a different argument. It is true that community laws embodying policies approved by the representatives of national governments would take precedence over the domestic law of member states, and that the British legislation in the fields covered by them would have to be consistent with community rules, yet this would be no innovation. That was the conclusion of the law officers, the senior legal advisers to the government. Their concern was about the continuing instance of future community legislation. Their solution was the United Kingdom Parliament could pass legislation enacting that community law should prevail over United Kingdom law if any conflict arose. The law officers see this as standard conflict management that is usually done in Parliament anyway. So contrary to popular belief, when a law is found to be inconsistent with EU law, the court will give precedence to European law, not because the ECJ says so, but because our Parliament says so. And our Parliament says so because we are British and we respect international law. And the constitutional implications are the ones that are laid out by Lord Kilner. Parliament has to give effect to directly applicable or effective EU law without the need each time for implementing legislation. The court loses its independence. And the court is now doing conflict resolution, a process usually reserved for Parliament, but primacy of law and direct effect are not new. Consequently, there's an argument that all of this is wrong. Not only have they taken the sentence out of context, not only is it not true that we didn't know about supremacy, the effect of EU law was not a constitutional innovation. There was a significant effect on our institutions, but not actually on our law. And so when Hugo Young says it is true that perceptions of what membership meant for sovereignty were more luridly understood in 1997 than 35 years earlier, that's kind of nonsense. Despite being an issue in 1998, there's no reference to Regulation 17 in Hugo Young's book, but in the 1960s and 70s, people would know about Regulation 17. Of the 3 points of Lord Kilmer, the first one is covered by Article 189. His third point is covered by Article 164, and the second one can be found in Edward Heath's speech of 1962. In referring to trade deals for India and Pakistan, he says, "They wish the negotiations to take place when we are members of the community, and they wish it to go on until the end of 1966, because that gives 1 year of qualified majority voting when the veto of any country will have gone." That's Edward Heath actively selling the advantages of majority voting on trade deals. And Hugo Young's problem appears to be that although he knows this is nonsense, his thinking and his approach still fall into it. To square that circle, one of the things he argues is that politicians didn't really care about the sovereignty. Well, that's not true. Months before the Kilmer letter was even written, the government announced their policy of political and economic unity in Europe. On hearing this, Harold Wilson's response was, "You can't possibly mean we're joining the common market," before saying, "We should think twice, and more than twice, before we commit ourselves to an organisation which will mean, in the end, not merely the loss of our economic sovereignty, because there will be no future for us or for the world if we are not prepared to compromise very seriously on our sovereignty, and not only our economic sovereignty, but will mean virtually relinquishing control of our economic policies. This is a point of great relevance to us on this side of the House." Again, I think Hugo Young portrays himself in this particular section. Lord Kilmer and Lord Hume both said there were serious surrenders of sovereignty. It seems this is the only thing good enough for Hugo Young. Lord Kilmer came to his conclusions by reading Article 189, Article 113, and Articles 164 to 188, specifically Article 177. And the effects to Parliament of these articles are in the debate in 1962. They're just not boiled down to a political theory like sovereignty. One of the reasons for this can be found in the sentence "one-sided surrender of sovereignty on our part." The word sovereignty is in inverted commas because it's a novelty. Many people in the UK in 1962 did not know what the word sovereignty meant, and those who had come across it would have done so as part of the end of the empire. It would have been a one-sided transfer of absolute sovereignty. If the government had published their legal and constitutional implications, as they said they would, then they wouldn't have said sovereignty either. And if you go over the Radio Time descriptions of their programs, these programs about sovereignty don't actually use the word sovereignty. But this one in 1967 does use the word, because there is a better understanding of that word in 1967. And it's also worth pointing out that the common market isn't just a treaty. It actually exists. It's functioning. And the 1960s and 70s are not the Dark Ages.
One of the European leaders who signed the Treaty of Rome in 1957 was Mr. Joseph Luns, Foreign Minister of the Netherlands. As a citizen of the Netherlands, Mr. Luns, how much sovereignty do you think you have lost by your country becoming a member of the common market?
Along with programming in 1967, in 1971, 7 judges from the ECJ came to London to talk about how this would affect our common law. And yet from Hugo we get, seldom, if ever, did the leading speakers address specifically the implications of the European Court of Justice. There was plainly much wariness about exactly how much to say and in what context. 14 years. The court had been in the debate for 14 years. Not only is it laid out in the government's case for staying in,
the government, in their white paper on the results of renegotiation, admit that Britain has given up some of its powers to the community. But they point out that whenever you join a club of any kind, You have to give up some independence and stick to the club rules. In exchange, you get the benefits of club membership.
But if you really missed it all, there was even more programming.
During those 20 years, but particularly in recent months and weeks, there have been countless explanations of the structure of the EEC, of the effects of joining, of the subtleties of sovereignty.
On Thursday night, the so-called sovereignty issue: by joining the common market, have we given up power over our own affairs, or have we gained the opportunity of greater influence in the world we live in? Join us for midweek at the market, starting tonight at 10:45.
Is the issue of sovereignty, which has been discussed and discussed and discussed.
The problem wasn't that sovereignty wasn't discussed. The problem in 1990 was that the Eurosceptics were wrong. And so James Goldsmith took the Kilmer letter and reopened the idea that it was going to be one parliament, one court, and one law. And while Hugo Young disparages this conspiracy theory, he still can't find a sovereignty speech in a book he's reading. He concludes that Macmillan is being evasive on sovereignty in a motion that's offering full transparency on sovereignty, and he seems to miss that Edward Heath is committed to releasing the constitutional implications. And by cutting out Harold Wilson, he also cuts out any discussion about sovereignty that comes about in 1967. His coverage of the Macmillan application is actually quite interesting. Hugo knows that they are talking about sovereignty, but he's not prepared to give up his original belief that somehow there was some concealment. To achieve this, he takes the position that things weren't said properly, and when they were said properly, they weren't heard, and when they were heard, people didn't care. And by dismissing this evidence, Hugo is able to carry on with the idea that sovereignty was not presented properly, which is what he needs to do if he's to present the Heath application with all the misrememberings, myths, and downright lies. Okay, that's the end of this one. If you managed to get all the way through it, thanks very much for watching.